All right, and the next case for oral argument is Glary and Israel via Brennan, Manna, and Diamond, 240835. We will pause a moment as counsel make their way forward. All right, and counsel, good morning again to each and all of you. Do you wish to have 5 minutes for rebuttal?
Yes, sir, if I may.
All right, 5 minutes will be reserved for rebuttal, 20 minutes total for argument for each side. Counsel, you're welcome to proceed.
Thank you. Good morning. May it please the court, my name is Daniel Glary. I represent the appellant in this case, Glary and Israel, PA. This case involves a fact pattern that I don't think has come before any court very often, so I think it's helpful to take a few minutes to explain how this case came about. Glary and Israel, PA was formed in February of 2001 to represent claimants in workers' compensation cases. Myself and Jonathan Israel were each 50% shareholders in that law firm. Mr. Israel's best friend's father was one of the incorporators of a local bank in Jacksonville called the Jacksonville Bank. And because of that, we were able to secure favorable financing through the bank in order to finance the practice. We borrowed approximately $700,000 in the form of a line of credit and a term note. We then used that money to purchase the practice from our former employer, and we brought all the former employees from that law practice into our own home. Aside from the cases that we brought from our former employer, the main source of our future cases were cases referred to us by the law firm of Harrell and Harrell, a Jacksonville firm that at that time advertised the back of the phone books. For the first year, everything went well. We were able to pay off the line of credit almost in its entirety. And in 2002, Harrell and Harrell asked us to join their firms as members of that firm, which we agreed to do. Afterwards, we only represented Harrell and Harrell clients through that law firm. Any settlements obtained in Harrell and Harrell case would be placed to the Harrell and Harrell trust account. And Glary and Israel maintained its line of credit and checking accounts with the Jacksonville Bank because we still owe the bank some money, and we still had some cases that needed to be processed under the former law firm's name. Almost from the inception, Mr. Israel and his former bookkeeper, Angela McDonald, began to steal money from the law firm. By 2003, there was no more liquid assets from the take, so they began to steal funds from Harrell and Harrell clients and put them into the Glary and Israel accounts. The Jacksonville Bank allowed that to happen, and it accepted almost $2.3 million in checks which on their face were payable to Harrell and Harrell or their clients. It had nothing to do with Glary and Israel. The Jacksonville Bank repeatedly transferred funds between the Glary and Israel line of credit, its trust account, and its operating account when there was an overdraft in those accounts. It twice changed the addresses on the Glary and Israel bank statements to the home address of Angela McDonald, our former bookkeeper, and it failed to ever bounce a check upon the Glary and Israel accounts, which would have brought this whole mess to light, even when our trust account was overdrawn by $254,000. In November of 2005, the Jacksonville Bank asked Mr. Israel and I to refinance our loan agreements. As we executed the documents, the bank officer stated, "Do you know that your trust account is overdrawn by $54,000? I immediately went to the bookkeeper, asked to get copies of the trust account ledger. She disappeared, later surrendered to the state attorney's office, pled guilty, and was sentenced to 15 years in prison, where she died of pneumonia approximately 3 years later. I didn't suspect Mr. Israel's involvement at that time. I was spending my time auditing files and trying to make sure that the clients who were owed money actually received the money, and Mr. Israel continued to represent clients to keep a stream of income coming into the law firm. In March of 2006, Mr. Israel was out of the country. We had a settlement come through the law firm where we could not locate the checks. It was a case that Mr. Israel had settled. So at that point in time, I terminated his employment because I didn't want to repeat the situation that just involved. Mr. Israel responded to the termination of employment by filing a motion to judicially dissolve Glary and Israel, to appoint a receiver, and to ask for an accounting. His contention was the assets of Glary and Israel were being wasted. Shortly afterwards, I discovered all the facts that I'd indicated to the court before involving Mr. Israel and the Jacksonville Bank. That primarily occurred is I had to go back from 2003, 2004, and 2005 and audit each one of those settlements to make sure all those clients had been paid correctly. And for those 3 years, it appeared that approximately $350,000 were owed to Harrell and Harrell clients, which that law firm paid. Approximately $26,000 was owed to Glair and Israel clients, which eventually the receiver was to have paid.
And Mr. Glary, I don't want to cut you off. I know this is a personal matter for you, but I want to make sure that we have the time to get to the legal issue that's really bringing us here today. So if we could fast forward to the settlement agreement that was entered into 2011, and then the subsequent case that was filed by you in 2015, help me understand how the statute of limitations did not begin to run at the very latest from that order of dismissal in, what was it, August of 2011?
Well, thank you, ma'am. Actually, that's a good place to interrupt because the next thing that happened was eventually the parties got tired of fighting with each other and they entered a mediated settlement agreement to resolve all the claims, released everybody, except Mr. Israel was not part of that settlement.
Did you sign that settlement agreement?
Yes, sir. The terms of that settlement agreement were all interrelated. I was to pay certain funds and release certain claims, which I myself owned as an individual, a shareholder, an officer of directors. But as long as the receiver was in place, I had no ability to affect Glair and Israel, and the settlement agreement doesn't state that I've settled Glair and Israel. The parties within 10 days made all the transfer of funds they're required to do. They signed their dismissals, and the receiver on August 12th signed a notice of dismissal at Jacksonville Bank, which Judge Wallace later found began the running of the statute of limitations of this claim.
Is this malpractice action, is it based on the settling of the claims, or is it based on the continuing work and formal conclusion of the receivership?
All of it, Your Honor. During the entirety of the litigation, the appellee, I would contend, took no action to benefit Glair and Israel. Instead, it did everything it could to protect the Jacksonville Bank and Mr. Israel. And
How was the
during that whole-
malpractice action based on the work of the receivership after the case was settled?
Well, Your Honor, a couple of things. Even after the case was settled, the appellee waited 2.5 years before it sought the receiver's obligations of the settlement agreement were to disperse the funds it received, to file a final tax return for Glair and Israel, to file a final accounting, and to dissolve Glair and Israel. All the parties, I believe, in 2012 thought that was going to occur fairly quickly. Instead, the receiver waited 2.5 years until December 13th of 2013 to finally fulfill its obligations.
But why did that preclude you from filing sooner? That seems to be your position, is that you couldn't do anything. But what is the legal authority for that position?
Your Honor, it's not me. It's not that Dan Glary couldn't have filed suit. It's that Glair and Israel could not have. That's the plaintiff in the litigation.
Why not?
Because as long as it was under the control of the receiver, nobody had any authority to act on his behalf except for the receiver.
What's your authority for that there was no ability to act at that point? I understand that you're saying that they're different, but what's the authority for that?
I'd just point to the history of the litigation, ma'am. At one point in time, I tried to file a shareholders derivative action on behalf of Glair and Israel because I was dissatisfied with the receiver and the appellee's representation of the law firm. Judge Schemmer dismissed that with prejudice, saying only the receiver can act on behalf of Glair and Israel, and not even the shareholders can bring a suit in his behalf as long as the receivership's in place.
When was that?
That would have been shortly before the mediation occurred.
So that was
Yes.
pre-settlement?
Yes, ma'am.
So, and everything occurred pre-2011, correct? Aside from you say that they didn't wrap it up quick enough.
Well,
All of these, the facts, the history here, you were aware of those facts when you signed the settlement agreement in 2011, correct?
yes, ma'am.
Okay. So, I'm confused how between 2011 and 2013, you're saying you lack the ability to file a suit or to act on behalf of the entity. How so?
As long as the receiver's in place, ma'am, it's responsible for Glair and Israel making decisions on its behalf and filing any litigation that's appropriate.
But where's the authority for that position?
I direct you to the amended order appointing receiver entered by Judge Cole back in 2006. It directs the receiver to retain counsel to represent Claire and Israel, to marshal its assets, to file quarterly accountings. And it says that the receiver may consult Mr. Israel and myself, but it's not required to. It can make its own independent decisions.
And irrespective of any alleged mismanagement, any issues that were going on, that just had to run its course?
Well, it depends. It depends upon when the settlement is concluded. Okay, even after August of 2011, the receiver then filed a final accounting that was off about $7,000. It was approved by the court despite that discrepancy, and the receiver then transferred an additional $5,600 to the Jacksonville Bank that wasn't owed, and in effect, the Jacksonville Bank had already filed this notice of dismissal with prejudice of his claims against Claire and Israel. So there's ongoing malpractice regarding Claire and Israel's, its representation of Claire and Israel in that regard. And that transfer didn't occur until after December 13th of 2013, as it occurred after the judge had discharged the receiver. Additionally, this case doesn't just involve the claims that failed to prosecute against the Jacksonville Bank, but involves the claims that filed to prosecute against against Jonathan Israel, who was also equally liable for that same malfeasance. The Jacksonville Bank, Mr. Israel is not a part of that agreement. Whatever happens, that agreement does not involve him. However, the receiver eventually not only dismissed any claims that it had against Mr. Israel without prejudice, but by sitting on his hands for 2.5 years, it allowed the statute of limitations to run against Mr. Israel for any claims that Claire and Israel might have wished to bring against it.
And was that raised below, counsel? Was the issue about Mr. Israel raised below?
No, ma'am. The only thing that occurred after the order approving the receivership occurred was 2.5 years later, Judge Cole had a hearing where she discharged the receiver. There was no litigation involving Claire and Israel, the receiver, and the appellate in the meantime. Okay? I think that Judge Wallace erred in saying that August 12th, 2011 is the date. Yes, August 12, 2011 is the date that the statute of limitations began to run, because Florida Supreme Court has specifically said the courts are not supposed to make a factual specific determination of when the statute of limitations runs in a legal malpractice claim. That's the case of Silverstone v. Edel, in which it dealt with a case involving a final judgment, and the court held that until that final judgment becomes final, meaning not only is the case over, but any appellate issues are resolved, that's when the statute of limitations runs for these legal malpractice claim, because until then, the aggrieved party cannot know with certainty that it's suffered any damages.
But there's a distinction between a final judgment, counsel, and a settlement, right? And
Yes, ma'am.
that distinction has been recognized by DCAs throughout the state, has it not? In Arrowhead specifically.
Yes, ma'am. Arrowhead Indemnity states that until the settlement is concluded in its entirety, the parties don't know if they suffered any damages. If the receiver had never filed a final accounting and sought his discharge, or paid the monies owed to Claire and Israel clients, the remedy that I would have sought would not have been to obtain an order compelling that to occur. I would have sought to set aside the entire settlement agreement.
Why didn't you do that previously then? Subsection K reserved jurisdiction for the court to enforce the settlement agreement, did it not?
Yes, ma'am?
And there was never a motion to enforce filed, was there?
It was not. Okay. But I have, Clary and Israel should not be prejudiced because of any actions that I took or did not take as an individual. I'm not the plaintiff in this case.
Well, how does a corporation act, counsel? Does it not act through its officers, through individuals?
Until the receiver is appointed, then it can only act through the receiver.
And if that receiver is not executing on their duties appropriately, as you allege here, then just too bad? There's no recourse for that?
Well, I may have sought to reopen all the litigation before, but I thought if I'm doing so, I think I would have done a grave disservice to Harrell and Harris Guidi and the other law firms that got sucked into these cases through no fault of their own. If I had to do over again, I wouldn't change what I did. I'd let the receiver, let the clock run as long as it can, because I don't think it affects the statute of limitations for the next argument in the appellant's initial brief, which is the appellee is equitably stopped to rely upon the 2-year statute of limitations when it prevented Glare and Israel from taking any action on its own behalf for 2.5 years after that settlement.
But it didn't prevent them. Equitable estoppel requires somebody is induced to act because of, in reliance on something else. You were well aware of what was going on. You made a strategic decision, it sounds like, to wait.
I did, ma'am, but once again, I am not the plaintiff. Glare and Israel is. I had no authority to act on behalf of Glare and Israel while the receiver was in place.
And you have no authority other than the court's order to say that you didn't have that ability, correct?
Correct. Okay. Then under the Arrowwood case, once the settlement was finally concluded, that's when the statute of limitations would begin to run on December 13th of 2013, and this case was timely filed on December 10th, 2015, within the 2-year statute. And even if I'm completely wrong about that, it bears noting that this case involves a summary judgment motion. And not only could a reasonable jury conclude that when the receiver fails to perform its functions regarding Glare and Israel, when the appellees take no action on Glare and Israel's behalf, instead they simultaneously represent the Jacksonville Bank up until October 2015 in over 140 cases. And they entered a settlement agreement which transfers money to the Jacksonville Bank, which Glare and Israel did not owe under any circumstances. A reasonable jury could certainly come back and say they cannot sit in control of Glare and Israel for 2.5 years after a settlement agreement, and then come back and say they're not equitably stopped to rely upon the statute of limitations, which only ran because they prevented Glare and Israel from taking any action on its own behalf.
And counsel, you are well into your rebuttal time. You have 3 minutes, 35 seconds remaining.
Thank you, sir. Lastly, there's an issue in this case about the Barton Doctrine. The Barton Doctrine requires that a plaintiff obtain leave of the court before it can file a lawsuit against the receiver or its counsel. That did not occur in this case. However, the case of DeSomi versus Rueda states that it's not necessary to obtain leave of the court when the complaint itself alleges the same self-serving facts which indicate the receiver acted outside his authority. And if it's alleged in the complaint, then they don't have to previously seek leave of the court. And I think that's essentially been conceded by the appellees in their motion, because they filed a motion that was titled Motion for Third Summary Judgment Regarding Statute of Limitations, which had nothing to do with statute of limitations. It all concerned the Barton Doctrine. And in that motion, they stated, if the plaintiff had any alleged claims against the receiver or its attorney, it should have filed leave of the court to file a suit. The plaintiff should have alleged the same allegations that it is currently alleging in the pending complaint, in that the parties were acting outside of their duties and engaging in a conspiracy to commit fraud. I don't think the Barton Doctrine is applicable in this case because the complaint itself contains the same allegations, and that's an alternative method to be able to prosecute a case when the receiver or its counsel act on their own behalf. Okay, thank you.
Thank you,
Thank
counsel.
you.
Yes, ma'am.
Good morning, Your Honors, and may it please the Court. My name is Lorraine Rabb, and I, along with Michael Orr, represent the appellee, Brennan, Mana, and Diamond. This Court should affirm the trial court's order granting summary judgment for 3 reasons. First, the appellant's claims are barred under the statute of limitations. Second, equitable estoppel does not apply here. And third, the trial court properly determined that the claims are barred under the Barton Doctrine. Under Florida Statute Section 9511, a claim for professional malpractice must commence within 2 years from when the action is discovered or should have been discovered with the exercise of due diligence. And a claim for legal malpractice requires 3 elements: the employment of the attorney, the negligence of the attorney, and that alleged negligence was the proximate cause of the damages. In Larson and Larson versus TSE, a Florida Supreme Court case from 2009, Justice Kennedy explained that a claim for legal malpractice accrues when the last element occurs, the loss to the client. So here it's important to pay attention to what Glary and Israel.
Saying that supersedes the Silverstone opinion, then?
No, Your Honor, it doesn't supersede the Silverstone opinion, it just distinguishes it, because if you look at the Silverstone opinion, that specifically relates to a case that results in a final judgment, and the Supreme Court explained that when there is a final judgment, that final judgment needs to reach finality for the damages to accrue.
Order discharging the receiver is not equivalent to that?
No, Your Honor, because here the damages occurred when the receiver, on behalf of Glary and Israel, filed a notice of voluntary dismissal with prejudice. At that moment, that dismissal with prejudice was final and immediate, and that's when the harm occurred. And if you look at all of the complaints filed by Glary and Israel and the Fourth Amended complaint, the damages Glary and Israel continuously allege is that as a result of the alleged negligence of Brennan, it entered into a settlement agreement in 2011 in which it forfeited its rights against the Jacksonville Bank. Those are the damages they are claiming, and that occurred and was final when that notice of dismissal with prejudice was filed by the receiver on behalf of Glary and Israel. And it's worth noting that the full extent of the damages is not required. As soon as there is some loss, the claim accrues, and that is what Justice Kennedy explained in Larson and Larson, and it is also what this court explained in the case of Otero versus Arcia. In that case, this court held that the Silverstone's rule merely establishes a bright line for establishing when the client has suffered some loss as a consequence of the attorney's negligence. It does not require that there be a determination of the full extent of all losses suffered by the client due to the lawyer's negligence. And here, as the appellant stated, it's apparent that Glary and Israel was aware of that loss. In fact, they filed a motion to disqualify the receiver and Brennan back in May of 2011. That was before they entered into a settlement agreement in July of 2011, in which they agreed to release any claims against the Jacksonville Bank. So the determination of the full extent of the damages is not required, and it's our position that the loss that they allege occurred with finality when that notice of voluntary dismissal was filed on August 12th of 2011, not 4 years later not when the receiver was discharged, and certainly when they filed the suit, which was in December of 2015, that was well beyond the statute of limitations. And as far as the application of equitable estoppel, that simply does not apply here. Equitable estoppel applies to avoid the application of the statute of limitations when a party is aware that it has a claim to file, but decides not to file due to the representations made from the other party. Here, there's no evidence in the record that would suggest that Brennan made any representations to Glary and Israel or intended to mislead or deceive Glary and Israel into waiting to file suit. Instead, the appellant simply argues that due to the fact that there was a delay in wrapping up the receivership, dissolving the firm, and discharging the receiver, that a jury could potentially infer and assume that that was an intentional act on Brennan's part to let the clock run for purposes of the statute of limitations. But there is no evidence to support that. And in fact, if you look at the answer brief, there's not one citation to the record which would point this court to any evidence in support of the application of that doctrine.
And counsel, what about Mr. Glary's argument that he couldn't act on behalf of the PA during the time that it was represented by a receiver?
Your Honor, Mr. Glary could act on behalf of Glary and Israel if he knew and he had reason to believe that there was a basis to disqualify the receiver and Brennan and Manna back in 2011, and he filed a motion to disqualify back then he could have also filed a motion for leave of court to file a suit against the receiver or to disqualify the receiver. Mr. Glary is a 50% shareholder of Glary and Israel. If he can't act on behalf of Glary and Israel, who can't? He certainly could have done that, but he chose not to. And that kind of leads to the Barton Doctrine, which is a big issue with this case because under the Barton Doctrine, an individual who seeks to file a suit against a receiver must seek leave of court from the appointing court to file that suit. Here, that did not occur, and the premise of the Barton Doctrine is subject matter jurisdiction. And the issue with this is it's the same subject matter. The receivership case ended in the settlement agreement, and then here we have the appellant trying to set aside that same settlement agreement within this legal malpractice claim. If you look at the fourth amended complaint, that is one of the things that the appellant is seeking to do here, to set aside the settlement agreement it entered to, which led to the voluntary dismissal of its rights against the Jacksonville Bank.
Isn't the Barton Doctrine only an issue if we find that the statute of limitations doesn't bar the claim?
No, Your Honor. I believe that the Barton Doctrine, if this court agrees that the Barton Doctrine applies here, then technically the trial court did not have jurisdiction to rule the way it did. But because the order on appeal included a ruling on the application of the Barton Doctrine, this court could affirm on the basis of the Barton Doctrine, and that would render the remaining issues moot. On the other hand, if this court determined that the Barton Doctrine does not apply, then the same result would apply as far as affirming as to the application of the statute of limitations, which bar the appellant's claims here.
And I recognize that courts have referred to the Barton Doctrine as a matter of subject matter jurisdiction. Do you agree with that, or do you think it's more an issue of potentially judicial comedy?
I believe it is an issue of subject matter jurisdiction simply because of the conflict when there's one court that's still, the court order approving the settlement agreement reserved jurisdiction to enforce it, among other matters, and that court would be in the best position to make a determination on the issues raised in this suit, and that is why the way this should have been approached would have been for Glary and Israel, or Mr. Glary, as the shareholder of Glary and Israel, to move to seek to disqualify the receiver back when he was aware of the basis for this suit, and that court would have been in the best position to address these issues. But because the appellant, Mr. Glary, chose not to do so, it led to further issues with this case, leading to the statute of limitations. And it's simply the appellant could have, should have, and didn't exercise its rights. And we're at a point now where Glary and Israel has had more than ample opportunities. This has gone through multiple judges. It's gone through 2 orders on motion for judgment on the pleadings. Judge Wallace continued to give Glary and Israel opportunities, and there's simply no way to get around the fact that the claims are barred by the statute of limitations and that there is an issue with subject matter jurisdiction. And if your honors don't have any other questions, we request that this court affirm.
Thank you, counsel.
Thank you.
I'd like to just make 3 final points. The first is that the statute of limitations is almost always an issue for the jury to decide and not a matter for summary judgment. I think that's the situation here. I think the court's correct. If this case does not survive a dismissal on statute of limitations, there's no need to address the Barchin Doctrine. The case is dead for an earlier reason, so we don't have to concern ourselves with the Barchin Doctrine at all. However, should the court get to address the Barchin Doctrine, it's important to note that no pleading was ever filed which sought the dismissal of this case based upon the Barchin Doctrine. What the appellee filed was a third motion for summary judgment regarding statute of limitations, and that's the style of the case. The body of that motion just concerns the Barchin Doctrine, not statute of limitations at all. And then the relief sought says, we ask the court to dismiss the case based on statute of limitations. It appears that the legal secretary was in the process of merging some documents, and a document was filed with the court that makes no sense. Even in the argument before Judge Wallace, no mention was made of the Barchin Doctrine. It wasn't until the appellee filed his written argument a day after the appellant had submitted its, and as required by the court, that it first raised the Barchin Doctrine as an issue. And I think doing so fails to give Glera and Israel proper notice as a violation of due process if regarding the motion for summary judgment.
But you had an opportunity to respond and object at that point if the Barton Doctrine had not properly been raised prior to the judge below entering the order. Is that correct?
No, ma'am.
You didn't have an opportunity when you filed a response?
Excuse me. Until the judge entered his order, there's no reason to think that it was going to consider the Barchin Doctrine when it wasn't raised or argued by the parties.
Once it was raised and you responded, you didn't think that that was, and that was prior to the court's order, is that correct? I want to make sure I'm not
Yep,
presupposing
the
something.
appellee's written argument was prior to the court's order. So I guess I could have jumped in and said, hey, wait a second, Judge, this doesn't smell right. And here's case law that says that the Barchin Doctrine shouldn't apply. But that did not occur in this case. Finally, I think one of this court's concern is whether or not it's inequitable for me to be prosecuting a claim on behalf of Glera and Israel when I did not assert those same matters in the initial litigation concerning Glera and Israel. And once again, I just point out to the court that I am Daniel J. Glera. I am not Glera and Israel. We are separate entities. Glera and Israel was taken from under my control to protect, I would contend, Jonathan Israel and the Jacksonville Bank.
And counsel, I hate to interrupt. We're 1 minute past the allotted time. I would invite you to bring your argument to a conclusion.
Thank you, sir. It did not come back into my control until the receiver was discharged. And at that point in time, any actions I've taken on behalf of Glera and Israel, you can attribute to that law firm. I don't think you can attribute any actions that I took or failed to take prior to the discharge of the receiver to Glera and Israel, PA.
All right. Thank you very much,
sir.
counsel. I'm sorry, did you have a question?
That's okay.
Do you have a question?
That's okay.
All right, counsel, thank you both very much for well-prepared, well-presented arguments. That will conclude the oral argument in this case as well. To our students, if you'll loan me just 2 or 3 minutes, I need to take a brief recess and then we'll come back out and answer any questions you may have and look forward to meeting you. What I would ask you to do, think of some good questions, but we cannot answer any questions related to the substance or merits of the cases that we've heard this morning, of course. But just loan me two minutes. We'll be right back. We stand in recess a moment. All right.